Hello again. And how are you doing? Enough food? Okay, good. Let's hear it as they walk out for the Columbia Orchestra String Quartet. Thank you so much. And I have to tell you, I'm overwhelmed by your generosity and support, but I have to tell you right now, I don't know if I'm going to get through my presentation because I'm speechless right now. I'm speechless at Bill Huffnell and Madero Wealth's gift to the Elville Center and that guitar, which I can't even imagine how much it costs. And it's a flagship item now for our charity. So I just can't thank Bill enough. So let's hear it for Bill's wonderful donation. And I also have to say that I was referred a client by Bill about a year or two ago. And this was one of the first times I had directly worked with Bill. And he came in, and he doesn't know I'm going to say this, but he came in prepared like no other financial advisor I have ever worked with. I mean, and I've worked with some really good ones. He came in so prepared that I was astonished. It was almost like a complete estate planning package specifically for this client that we were getting ready to meet with. So I'm just amazed. Thank you again, Bill and Billy and Dan. Thank you so very much. Okay, as I get ready to get into my presentation, and you know sometimes we run long, I'll try to be efficient. I just wanted to recognize our audio-visual crew again, Drew, Dalton, and Olivia. Thank you for what you're doing today. And I know that they are, taking panoramic pictures of the room and getting you in the photographs and in the video, so thank you for allowing them to do that. And they've assured me that if you don't like the way you look, they'll use AI to make you look better. And they've assured me that they'll do it to make me look taller. Okay, and I also just want to say some of the things I'm going to talk about are going to be redundant. Some of you know I'm intentionally redundant, but this time it's going to be because I'm going to kind of go back over some of the material in just a small way that Dan and Bill presented. I'm also going to hit on some things that Lillian Hummel, who I'm very proud of. Lily is our elder law principal attorney in our Rockville office, and we're looking forward to Lily's presentation. And Lily is just a great leader, a great lawyer, and she really knows her stuff under the hood of some of the stuff she's going to be talking about that's so important. And the last thing I wanted to say as an opening remark is, Dan, you're not alone as a tax geek. And it's not me that I'm talking about. I'm talking about Professor Sam Donaldson, who is probably the nation's #1 estate planning tax geek. He's a professor at Georgia State University. And I'm going to encourage Dan to get in touch with Professor Donaldson because Professor Donaldson has, according to what he says, 56 different colored sweater vests. Okay. So some of you in the room will get that one. Okay. All right. So we're going to talk about the big, beautiful bill. And there are winners and losers. And most of us in this room are the winners. The bill is very favorable, no matter what side of the political aisle you're on. For people who are doing estate planning, building their wealth, and so forth, the bill is very favorable, right? And for some of us who are on the elder law side as well, we know that the bill sometimes is a bit tenuous, and we're worried about it. We're worried about 2026. Lily is going to talk a lot about this in her presentation. We're going to talk about the people who are maybe not the winners in the bill, the people who are on needs-based public benefits, and what's going to happen to the Medicaid system in 2026. So we know there's two sides of this bill, winners and losers, but we're going to focus on the positive side this morning, at least in my presentation. But I'm a big believer in getting grounded before we get into the material. So if you don't mind just participating with me just a little bit, you are a very good audience. So Uncle Sam loves what? Taxes. But Uncle Sam also loves acronyms. So Dan said, hey, Steve, I like that OBA. So let's talk about this. Please repeat after me. One big. Oh, okay. Let's try that again. One big bodacious. Now, I've got my phone here. I'm using AI. One big bubbly bill. One big believable bill, one big bountiful bill. Um, you get my point. So this bill is wild, okay? And we're going to talk about the mostly the positive things. So I don't think we can call it a benevolent bill, but for those people who are doing estate planning, it's very positive. So one big beautiful bill act, okay? OBA, not OB3 or Star Wars or anything like that. All right, Jeff, I'm looking for my clicker. Here we go. So thanks for playing along with me through that. So we're going to talk about OBA. All right, so obviously this is not legal advice, as Dan said, but we're going to talk about trends in contemporary planning. We're going to make sense of the modern estate planning tools in OBA. We're going to stay abreast of change. We're going to talk about flexibility. I'm going to be nautical this morning. I have my nautical tie on. So for those of you, how many of you have been out on a boat recently? Power boat, sailboat. How many of you have been out on the ocean on a power boat or sailboat? Okay. How many of you been on a cruise ship? Okay, you guys have been out on the ocean. We're going to talk about the rudder and the emergency tiller. We're going to talk about IRA distributions to trusts. We're going to talk about the winners and losers a little bit. We talked about that just a minute ago. And we're going to talk about one of the most important things is the client care program, maintenance and updating. Okay. Let's talk about OBA. Bill talked about the 15 million basic exclusion amount, the BIA in 2026. So this is inflation based. So we got 15 million of exemption per person. We have 5 million of exemption in Maryland per person, so 10 million between a married couple. I don't think there's anything else to talk about. Let's just end the presentation right there. Oh, you mean there's something else to talk about? Okay. Well, all right, we'll go beyond the 15 million exemptions. We'll go beyond all of that. So let's get into the income taxation side. So Bill mentioned and Dan mentioned the SALT deduction. So through creative planning, you can actually create additional SALT deductions. So what are we going to do today? Well, we're not going to be able to get into depth on these things, but I want to give you the general idea of what is available out there today. What is generally available in estate planning? So you could create additional SALT deductions by shifting income. How many of you have heard of the 199 Cap A deduction? Okay, this is where business owners can reduce taxable income by 20%. Some of you have heard about that, or you know people who are qualified for that. So you can create additional 199 Cap A deductions. One of the things that's amazing is qualified small business corporation expansion, where capital gain exclusion is increased from 10 million to 15 million. These are people who are doing startups, and the government is encouraging people to invest in startup businesses, and then pretty much you can exclude capital gain almost 100% on the sale of those businesses. So you can increase or create additional QSBS exclusion. So it's amazing for the winners on this bill. It's amazing what can be done. No tax on tips. Now, for those of you who really have read about this, there's going to be a tip jar out here for the lawyers because there's no tax on it. There's no tax. When you come to our office, there will be a tip jar on every table. Of course, I'm just kidding. How many of you have heard about the Trump accounts? Okay. All right. So doesn't matter what side of the political aisle you may be on. This is like an amazing thing for like IRAs for young people, right? So on July 4th, 2026, you'll be able to open a Trump account. Those of you who have loved ones with disabilities or have a disability yourself, the ABLE laws have been expanded now. We've been talking about this for years. You can be qualified for an ABLE account up to age 46. The annual exclusion from gift tax is $19,000. Opportunity zones. Now, many of you in this room are not going to be maybe investors in opportunity zones, but the laws and the incentives for people who are investing in opportunity zones, it's amazing stuff. And of course, Bill and Dan talked about charitable planning. Now, this is a chart. Bill and Dan talked about this. Bill, you're absolutely right that It's like $768,000 that a married couple can make prior to being in a 37% bracket. 640,000 and other, for single filers, 640,000. These are amazing things as far as taxable tax brackets. Now, look at this for many of you who have trusts and you're leaving trusts for disabled loved ones or people that need asset protection or creditor protection. Many of you now are somewhat surprised when you revisit this and you see that in 2026, any taxable income over $16,000 is going to be hit at 37%. So we have to remember, don't be shocked by that, learn how to manage the taxable income of a trust. So remember, if income taxation of a trust was not manageable, we would all be running for the hills, right? We wouldn't be using these kinds of trusts. So just take heart that you can learn about how to manage the tax ramifications of a trust where you are leaving assets in trust for a loved one or a spouse. Now, under OBA, we have to keep in mind, and I was talking to a couple of clients this morning, we can't always worry about everything, right? But a future administration, the exemption amounts could lower, and Bill mentioned that. So we have to keep that in mind. Now, I'm going to be talking a little bit of tax science here. So if you get lost or you say, what am I doing here? You're normal. Just bear with me, all right? You may be a person in the future who creates an incomplete gift non-grantor trust. Talk about tax geek stuff. This is because if we create those kinds of trusts, we could increase our exemptions for SALT, 199A, and other purposes, and still get a step up in basis. So what are the tax gurus saying? And Dan alluded to this. We're living in an environment where, and Bill said this too, finding ways to increase basis, right? How can we get a step up in basis, okay? Well, we might do that through limited powers of appointment. If you don't understand this, at least you're getting this. And the gentleman here asked if these slides would be available, and the answer is yes. We're going to talk about downstream planning. Okay, how can I shift income to lower tier generations? How can I shift income down to my kids? Okay, that might be a strategy. How can I use a general power of appointment to shift assets upstream? Now, this is really a wild concept, right? If you've never thought about this, what if you have an older loved one who has a modest estate and you might leave them something and give them a general power of appointment over the assets? I know that sounds like rocket science on a Saturday morning, but basically using their exemption amount and they get a step up in basis. So there are ways of thinking about this, but there are risks involved. And I'm just trying to make you laugh, but what if you give grandmother a lot of assets and use her general power of appointment, and she uses that power of appointment and gives it to someone you wouldn't want her to give it to? So there's all kinds of non-tax reasons why we wouldn't necessarily do something like that. A community property jurisdictions, so like Alaska, Tennessee, places like this, you could get the benefits of community property. Some of you in this room I know have community property, and you understand what the step up in basis advantages are of community property. But some of you don't have community property, and you might have an asset that you want to achieve a big step up in basis. Well, you could use Alaska law, and you could achieve a step up in basis. So it's kind of hard to believe that this is the world we're living in, but it is the world we're living in for planning. Now, a lot of us would, and along the lines of what Dan and Bill were talking about this morning, unwinding a trust. And Bill, I don't know if you caught this or not, but Bill was really mentioning about what happens if we have a revocable living trust, and at the death of the grantor leaves a non-marital trust. And some of you know what that is. It's a bypass trust or a family trust or a credit shelter trust. Well, that trust doesn't get a second step up in basis, okay? So what if we wanted to undo that kind of trust? Well, you can undo it, but look at how cautious you probably need to be there. Well, there might be Medicaid issues. You're undoing a trust, okay, but you might be creating a Medicaid issue. You might be. There are general creditor issues. What if the person has creditors and you unwind a trust that is giving that person asset protection? What if that person is possibly going to have a divorce or incapacity issues? Or What about the trustee of that bypass trust? What if that trustee has fiduciary duty, which they do, and now because the trust was terminated, that person could be sued by someone. So you can't unwind these trusts without being very cautious, okay? Now, how many of you have heard of a spousal lifetime access trust? A SLAT, okay? I'm seeing some people raise their hands. Why would somebody create a SLAT since 2012? Well, what they might do is they might gift some of their assets into this trust, and those assets are frozen. This is for married people now. And those assets are frozen from estate tax forever, and they are grantor trusts, meaning you can have the best of all worlds. You can remove assets from your taxable estate, and you can still pay the tax on your own 1040. So many of these trusts were implemented up until just recently and still being implemented because people want to use their exemption amounts before the exemption amounts were going to what? Go away. But the exemption amounts did not go away, did they? And they just keep going up. So some of these slats might need to be undone because do they get a second step up in basis? No, they don't get a step up in basis because what is a slat? It's a fancy way of saying I'm creating a non-marital trust during lifetime. So a slat is no different than a credit shelter trust or a bypass trust during someone's life. But how do we get out of these trusts? Well, if we do want to get out of them, we might just distribute the assets to the spouse. But there could be all of these other issues, divorce issues, creditor issues, or we can decant the trust. One of our wonderful clients said to me just a few minutes ago, Steve, thank you very much for talking to me for 15 minutes and not mentioning the word decanting. And so I said, thank you very much. But how many of you know what decanting is? All right, so decanting, Jim says he knows. Decanting is the ability to substantially amend an existing trust. How many of you knew, and you may have to get another cup of coffee for this one, how many of you knew that an irrevocable trust is not irrevocable? All right, so if that didn't make any sense, you're normal. So in the law, we now can change irrevocable trusts if you didn't know that. And that may come as a great surprise and may even cause anxiety. But remember that this is the world we're living in. We have millions of irrevocable trusts, and these trusts can't be changed except by judicial modification in the past. But now the law has evolved. So I'm going to let you think about decanting or look it up or Google it. And when you do, you may be shocked that an irrevocable trust can be changed. But I'm very happy with the Maryland decanting law that we've had now for 2 years. And it has a big emphasis on, I will just say, common sense. Sarah von Stein Echeverria is our resident expert on decanting. So if you have questions about decanting, and Sarah is still in the office right now, she and I would be happy to talk about that. But just have the comfort and the idea in mind that your irrevocable trust that you leave for your spouse or your loved one, your disabled loved one, that can still be changed in positive ways. Now, are there states that have more outrageous decanting laws, like Nevada and places like that? And the answer is yes. But I'm very happy with the Maryland decanting law. You can substantially amend a trust or change it to a new trust within certain confines, and I think you'll be very happy with it when you learn about it. Now, again, we've got these existing credit shelter trusts. I got a little bit ahead of myself, but how would we change that? Well, how do we get the step up in basis back? Well, we might do a non-judicial settlement agreement. That's a mouthful. So that's, let's say, one step short of a decanting, where everybody agrees that the trust can be modified. So that's kind of an informal way, and it works sometimes and it doesn't. Give a spouse a general power of appointment. What is a general power of appointment? The spouse can give it to whoever they want, basically, including creditors. That's a general power of appointment. And if you have a general power of appointment over something, that means that it's taxable in your estate. And if it's taxable in your estate, you get a step up in basis at your death. Okay, so if you have a revocable trust, you have a general power of appointment over that trust. Okay, it's going to be taxable in your estate. So the more general powers of appointment we have, the more step up in basis we're going to get. And that's a very advantageous thing right now under OBA. But if we have a general power of appointment, can creditors get into the trust? Does anybody know the answer? So, yes, when you give someone a general power of appointment, that person's creditors might be able to penetrate the trust. So, we've got to be careful about general powers of appointment. So, we have creditor protection issues. We need to use caution. And again, we could even use decanting to add a power of appointment. So, that's a lot of stuff. And we've been talking about non-marital trusts. Non-marital trusts, like slats, give us a frozen assets for estate tax purposes. So if you left $1 million to a non-marital trust and the surviving spouse lived another 35 years and that grew to $10 million, all that money is estate tax free, okay? But it does not get a step up in basis. So that's what we're worried about. But some of you have marital trusts, not non-marital trusts. And these are sometimes called Q-tip trusts. So Uncle Sam has a sense of humor. And there's another acronym for you. So what do we have to be worried about if we have a Q-tip trust and you want to unwind that Q-tip trust? Now remember, a Q-tip trust gets a second step up in basis. So as we're talking about OBA and basis, you can get a second step up with it. So we don't need to unwind it. But what if we did unwind it? You might think, well, that's a great thing. My spouse, I wanted to protect assets from a remarriage. I wanted to give my surviving spouse asset protection. But now I'm okay if they want to unwind it someday. So whether you agree with that or not, let's say it's unwound. Well, when you read these, which you have to be pretty bored to read these, but if you read these, you're going to see that it's not as simple. Your beneficiaries, believe it or not, under these cases and these PLRs, could be deemed to have made a gift to the surviving spouse, and that could trigger a gift tax. So when we unwind trust, the thing to remember about is you don't want to do it without really thinking through it. All right, now we're going to get a little less technical. If you're still with me, feel free to get up and get some more food, get some coffee. I'm going to ask you how your flexibility is in your planning, okay? So for those of you who are more nautical minded, or even those of you who are cruisers, I know a lot of you go on cruises, okay? I'm going to ask, how's your ship? How's your ship? Your estate plan? How's your crew? You know, how are your fiduciaries, your personal representatives and trustees, and your selection? And when's the last time you thought about that, okay? And are they educated? You're an educated group. You came out on a Saturday morning and you've been very generous to come out. But how is your plan designed? What is your goal? Do you have trust protectors? Do you even know what a trust protector is? Are you a person that's comfortable with trust protectors? I have two or three clients that are not 100% comfortable with trust protectors, and they want to be very cautious about the trust protector's powers. But the reason I'm very proud of these clients is that they're really thinking through their planning. Personal representatives, the person who's going to be your executor, other special fiduciaries. And then I'm going to ask you, are you familiar with the pressures that your estate plan could come under? So for those of you who are nautical, I was just talking to John, and he's a sailor, and he knows I'm a sailor. And we were talking about boats. And how many of you are familiar with what part of the boat, from my understanding, comes under the greatest pressure when you're out on the ocean? What is the part? John? The captain. The captain. All right, I agree with you. All right, well, do you want to come up? No, that's a great point. So my understanding is the rudder and the rudder mechanism on the boat is what comes under the greatest pressure when you're out on the deep ocean and you're in some high seas or whatever. So I'm just going to ask you, when you look at your estate plan, how deep is it? How strong is your, and how many of you knew that if your rudder goes out, that on a sailboat there's an emergency tiller, right? Even if you have one of those big wheels and you're on one of these big fancy sailboats, there's an emergency tiller that if worse comes to worse, you have to grab that thing and mount it, and you have to steer your ship by an emergency tiller. So this is a serious thing if you're out on the ocean. So I'm going to just analogize your estate plan to this. If push comes to shove, right? If there was a crisis, God forbid, I think in the last 2 months, we had at least 6 or 7 crisis cases, which is kind of unusual. Like something horrible has happened. Somebody has had a health issue. At a time of crisis, is your estate plan flexible? Is it updated? Because that's the first thing I ask. At time of crisis, like, does this person have the power of attorney? How broad is this power of attorney? What can we do? So we want to have strong documents. So but now back to a little bit more of the more advanced issues. So we need to be aware that hopefully we have the flexibility in our documents, but we want to at least somewhat understand what a non-judicial settlement agreement is. I'll give you an example. 20 years ago, if we were having this meeting, there were no flexible approaches in Maryland law. Maryland law was really horrible. Power of attorney laws were horrible. And Maryland didn't get up to speed on its trust laws until 2014. And since then, the Estates and Trusts section of the bar has done a wonderful job of modernizing Maryland planning. So we have all these things, and if you're not familiar with these things, you should make yourself aware of it. Decanting, can we opt out of decanting? And some of you who are members of the client care program, you may remember our presentation about 6 months ago. We talked about some of this, and you really can't opt out of certain things. And some states allow you to opt out and some states don't. So that brings up the issue, which, Jeff, you'll have to put the hook up here if I'm going too long. Some states allow you to opt out of some of these things, and Maryland doesn't, and many states don't. Do you have a planning team? Do you have a financial advisory team that really advises you at a high level, and your CPA team? Do you know who your advocates would be or your aging life care managers? We had Allison Stanton and Stanton Aging here last year. I just told a young lady who works for them that I probably refer 2 or 3 cases a week out to them. This is how prevalent the need for aging life care managers are. Memorandums of intent and letter of wishes. Do you need life insurance in your plan? Many of you are going to have large IRAs that are going to have accelerated income tax. Are you going to use life insurance as a tool? I'm not saying you have to. Are you going to use that as a tool because there's going to be accelerated income tax to your beneficiaries, right? So there may be issues having to do with Maryland estate tax. So we live in the only state that has a state estate tax and an inheritance tax, right? Now, thank goodness, not everybody is subject to inheritance tax. So think about life insurance being the Swiss Army knife of estate planning, and do we need it? I just mentioned multi-jurisdictional opportunities. Some states you can do certain things, some states you can't. Those of you on the elder care side of things or have relatives that have elder care issues know that oftentimes we have to talk to people about going to Delaware for elder care because Delaware has more waiver programs. Now, on the flip side, let me give you an example. Let's say that you wanted to provide the greatest asset protection possible for your children or your nieces and nephews, and you said, Steve, how can I attain that? Well, when you die and you leave an asset in Maryland in trust, the asset protection is pretty good, depending on who the trustee is. Is it an interested person? Is it an independent person? Well, I was just talking to a trust company the other day that services a lot of financial advisory firms, and he was pointing out to me that when they serve as an independent trustee, because they are a South Dakota trust company, and I know a lot of you think this is like weird stuff, but it's commonplace now. Your child's trust or your niece or nephew's trust, if they were the independent trustee, they automatically change the jurisdiction to South Dakota, and South Dakota has the greatest asset protection of any state in the country, arguably. And there are 10 times more assets in South Dakota than any other asset protection state. But you can attain that kind of asset protection by understanding that the world we're living in today is multi-jurisdictional. All right, powers of appointment. We talked about downstream planning, upstream planning. How many of you have a letter of wishes attached to your trust? It's very easy to do. A lot of people are raising their hands. I'm very proud of those people. But just remember, you can design your informal wishes. You can also use a trust advisory committee. You could say, well, I want my trustee to have to be advised by 2 or 3 other people who are going to carry forth my wishes. What I want you to take away from this is we're living in a world where you can design your estate plan in tremendous detail. IRAs and distributions to trusts. So we have all kinds of issue here that we're not going to be able to get into because of time limitations. But how many of you have read an article maybe that you should never leave an IRA to a trust? Well, those articles are out there. And one of the reasons those articles are out there is because they say, oh my gosh, if you leave an IRA to a trust, it's going to cost 37% tax. And there's a lot of truth to that. So remember two things as we talk about this very briefly today. The Supreme Court ruled probably 20 years ago that when you leave an inherited IRA to a loved one, they do not have asset protection. So just remember that. You have asset protection, but your loved one does not, according to the Supreme Court. So if you leave the IRA to a trust, they will have asset protection. But now, because of the Secure Act, we have to say, oh boy, most healthy beneficiaries now have to pay tax in 10 years. So how are we going to deal with the taxation of an IRA in a trust? So it doesn't mean you should give up on the asset protection. It just means we should talk about how to deal with it, okay? IRAs payable to marital trusts, okay? IRAs payable to trusts for children and grandchildren. We just talked about that. IRAs payable to a disabled person. Well, we know that's going to be the easiest solution because they are exempt from the Secure Act. But a lot of us don't understand the difference between trust accounting income and fiduciary accounting income. And how do we think about leaving IRAs for spouses in trusts? And many of you are going to leave IRAs outright to spouses, and that's going to be the simplest thing. It's going to be the most efficient thing. But there's all kinds of sub-issues if we are leaving IRAs to trusts, especially for spouses in trust. Remember, if we have a trust and we have income in a trust, we have 65 days into the new year to get the income out of the trust, okay? And this is another concept that you should just understand. Bill mentioned this. And Dan mentioned this. IRAs are income in respect to a decedent. So that just means they're going to be taxed and they're going to be taxed like savings bonds and so forth. So these things are called IRD. And there's one special thing I want you to see right here. Even though 99% of people in this country are not subject to an estate tax, just like Bill said. I don't know why they just don't eliminate the estate tax altogether, but 99% of people right now are not going to pay an estate tax. But look at this 691C deduction, okay? Let's read this. If a federal estate tax is assessed on someone's estate, and remember, that doesn't happen too often these days, the decedent's estate is entitled to an income tax deduction for the estate tax that was attributable to the IRA. Now, that's a very big deal if you or someone you know is going to pay an estate tax. All right, so just remember that 691 deduction. There are wonderful charts out there. One of the tax gurus in estate planning that we follow is Robert Keebler. Robert Keebler is a CPA out of Wisconsin, of all places. He has some wonderful charts if you want to look at charts and understand what happens with regard to minimum distributions after someone dies. And remember, eligible designated beneficiaries, people who are not subject to the 10-year rule, are who? People who are less than 21 years old, meaning minors for purposes of the Secure Act, spouses, people who are less than 10 years younger than the plan participant, okay, chronically ill people, disabled people, and their special needs trust. So all these people are eligible designated beneficiaries, and they're not subject to the 10-year rule. Now, I'm not going to spend a lot of time on this because this has to do with IRAs into trusts. So we're going to, in the interest of time, just keep moving. We talked about spousal lifetime access trusts. Some of you may want to use an irrevocable trust for purposes of attaining some kind of a step up in basis. So again, we're able to exclude $30 million between a married couple, $15 million between a single person, and it's indexed for inflation. So that doesn't mean there's going to be an estate tax, but there are still opportunities to think in terms of removing assets from what? The Maryland taxable estate. So remember, we've got estate tax planning and we've got basis planning, but we live in Maryland. So the easiest way to eliminate your Maryland estate tax is to do what? Move. But we don't want you to move. We don't want you to move, but you could. So if you're not going to move, though, we have to realize that many of you are not going to have a federal estate tax, but you're going to have a state estate tax, and there are things to think about that we need to think about. All right, so I'm going to just keep going now. Life insurance trusts. If you buy a big life insurance policy to pay for Maryland estate tax, not federal necessarily, or the accelerated income tax under the Secure Act, would you just buy that life insurance and put it in your taxable estate? No, you would put it in a life insurance trust. So that I'm just going to argue that life insurance trusts are still very, very valuable. I'm not going to spend a lot of time on it. Some of you have cash that's sitting around and it's just earning interest, and maybe you would like to get that extra interest or investment income out of your estate. You can use a grantor retained annuity trust. Is the purpose of all this that you're going to remember all of this? No, but it's to let you know that these things are available, just to remind you. Medicaid Asset Protection Trust is arguably the most powerful tool in estate planning today. You can exclude assets from your Medicaid estate or your long-term care estate. You can still retain some control, and you can still get a step up in basis. So this is part of the discussion of basis planning. A Veterans Asset Protection Trust might allow you to do the same thing, but accelerate your benefits eligibility for the VA pension that you might be eligible for. Now, as I start to wrap up, and I know the ladies are here, Jeff's going to give me the rope here, or the pull thing here in just a second. Let's end by starting to talk about some things that we talked about at the client care program a few months ago. So as we enter into a world now where we have gone from, these are my words now, no flexibility to massive flexibility, okay, in estate planning. You need to be aware that things that you put into a place may not actually be written in stone. And this may cause you some consternation that my estate plan could be changed in the future by somebody. These new flexibility laws are off the charts. What is the risk to my planning? So I think it's just a healthy thing for you to be aware of what these tools are. Now, for example, this is not one of necessarily those tools, but no contest clauses in your revocable trust or wills. Generally, these are not enforced across the country. But there is information available about how to think about this and how to bolster your no contest clause if you have a worry about a particular beneficiary, a child from another marriage, or someone else who's going to cause trouble for your trust or estate. Arbitration clauses. Only 5 states have really addressed this, but I hope what you take away from this is the estate planning world is continuing to evolve just like everybody else. Maryland has not addressed this issue. Videotaping, there's some risks, there's some rewards. This has been around for a long time. So Maryland does look at this in some ways in a positive way, but there are risks involved. Now, back to my original point. Trusts are not irrevocable necessarily, okay? So how do you ensure your wishes? How can you make sure you have the greatest asset protection? For example, if you wanted to avail yourself of South Dakota asset protection after your death, it doesn't sound like a logical thing, but this is the world that we're living in. Doesn't mean Maryland law is bad. It just means that some states have enhanced asset protection. So there's new modifications in the law over the last several years. How do you manage this? Well, you manage this through trust protectors, letters of wishes, decanting, understanding that, and just having educated fiduciaries and an educated advisory team. Choice of law, we just talked about that. What is the best jurisdiction? Okay. Trust protectors have been in the law since 2014. We talked about decanting. 23 states, as of a year ago, had decanting. Maryland got it on October 1st, 2023. If you haven't read an article about decanting, we have a presentation we did on it. You're welcome to look at that in our video library. So can you really limit the decanting? No. There's no carve out for it in Maryland law. So you need to be aware of the changes that could be made. Could you limit it or attempt to limit it? Yes, you could attempt to limit decanting, but in reality, you're not going to be able to do it 100%. Non-judicial settlement agreements cannot be limited. I'm going to move on just in the interest of time because they're going to give prizes here in just a moment. Directed trusts. This is a real opportunity for those of you, depending on who your broker dealer is or your financial advisor. You may have certain choices to have a directed trust where you can take advantage of corporate independent trustees at a low cost. So remember, there are pros and cons of all kinds of choices with individual independent trustees, individual interested trustees, corporate independent trustees. This is all the part of updating and maintaining your plan. So as I wrap up, I always say, what is your goal? I know, Bill, the Huffnells and Mandura Wealth believe in that same thing. What is your goal? Does my goal in planning require future flexibility? Well, I would argue 95% of you are going to want that flexibility. But there's so much flexibility. I want you to understand what's out there and what if we just closed our eyes over the last 10 years, we would not even know that a lot of this has happened. So you need to educate yourself. Does my goal require that you try to restrict certain flexibility? So maybe it's a jurisdictional issue we would have to address. And remember that it may not be possible to restrict. Now, before I start to really close, remember, one of the big issues in this presentation is the idea that under OBA, okay, it's a very positive environment for planning, right? Not so much on the public benefit side, but on the positive side of planning, it's very, very good. So obtaining step up in basis, okay, because we have so much general estate tax exemption, except for the Maryland estate tax. We have so much exemption that we can focus on income tax planning and basis planning. So just remember, you may be a person who wants to shift income from your level down to another generational level, shifting income down into trusts for others, creating more exemption, creating more basis in other types of planning. As I start to wrap up, I want you to always remember, look at these fiduciaries: trustee selection, trust protectors, personal representatives, financial agents, healthcare agents, trust advisory committee members, your preferred financial advisors, your CPAs, aging life care managers, other special fiduciaries in other states like Delaware. So if you're not a member of our client care program, we strongly encourage you to stay in touch with us and stay abreast of change and also have some fun, as you see down here at the bottom. Our client care program members are fun. And if for no other reason, you should join our client care events so that you can hear Gary tell jokes, because he's very good. And we do get high alerts, right? Like the Corporate Transparency Act, right? Oh my gosh, Jeff started telegraphing our Corporate Transparency Act alerts several years ago, and it turned out to be nothing because it's been ruled unconstitutional. But these are the bombshells that come out of nowhere that you would need to know about. Legislative updates, family and fiduciary education, and again, how much flexibility do you want? And that's a different question, but that's an ongoing question. Jeff, you didn't pull me off the stage, but thank you very much. Thank you very much. Thank you, everyone.